Yep.
I'm going to do that now. I'm going to admit the people. All right.
Yep.
Thanks, Charlie.
Good evening, friends. Welcome. Just wait while I can see people are connecting to audio and so on, and then we'll start. All right, let's kick off. We may have people join us. We're also recording so that we can share this with people who weren't able to make this particular time. So we like to welcome you to this webinar about the upcoming rental reforms. Before we start, I'd like to acknowledge that we're coming to you from Aboriginal lands. I am calling in from Darramurrugal country in the north of what's now Sydney. I'm Leo. I'm the CEO of the Tenants Union of New South Wales, and I'm joined by Lehana de Silva. Lehana, who are you and what land are you on?
Thanks, Leo. My name is Lehana. I'm the Solicitor Aboriginal Support at the Tenants Union, and I'm meeting from Gadigal country today.
And so we pay our respects to the owners of the lands that we work on both tonight and every day across this country. Uh, for those who aren't familiar with the Tenants Union, a quick introduction. We're an independent charity and a specialist community legal centre working particularly around tenancy law. So we create information, education resources, and all sorts of tools to help people navigate the renting system. And we work with a network of tenants advice and advocacy services across the state, and we provide training and backup legal advice for those services. And we've also been campaigning and working to improve the laws around renting and the policies around renting since 1976. So we've spent a lot of time talking to renters about the issues that they face and trying to help make their renting experience better. And this uh, series of rental reforms really comes out of a lot of the experiences renters had been talking to government, to the rest of the community about for many, many years. And the chief one is the no grounds evictions, which people have been reporting for more than 50 years, how that has impacted the way that they rent, particularly that feeling of a lack of security, that feeling of, uncertainty around your renting rights. No matter what's written down, if you can be evicted, then that puts a real dampener on your ability to actually pursue those rights. And so this was something that had really become a key element of rental reform for many, many years. And we've now achieved passing the legislation through Parliament, and we're now weeks away from this becoming live, active law that protects people. We're also, hearing more and more, particularly over the last few years, but it's been a long-term problem. Of people receiving very large rent increases and rent increases that meant that they could no longer afford to stay in their homes, stay in their communities, and be, feel a part of the community that they had been living in, sometimes for many years. So this was something that was continually being raised. Um, these sort of problems have meant that renting has become much more of an issue that governments are trying to get a handle on and show that they are responding to. They haven't responded to everything that we need yet, but these are some really significant changes. And so this webinar is about looking forward to those changes, making sure that people know exactly how they are going to work and how they're going to affect their renting experience. So, uh, what has changed already? Uh, these laws passed in October last year, and some of them it started from the 31st of October, and others will take a little while longer yet to kick in. So, what is already in effect are two key changes. One is a 12-month time limit on rent increases that had applied to some tenancies in New South Wales. It is now being extended to every tenancy, regardless of fixed term or periodic, and we're going to talk a little bit more about that detail soon. And there was a ban on the charging fees for background checks. So people were being asked to pay for things that had various names. Rent check is one where while you were applying for a property, particularly through the online forms, you were being prompted to pay $20, $25 to perform a background check on yourself. And being asked to pay for that has been banned. So those two things came into effect from 31st of October. And what is coming up is the end of the no grounds evictions. We'll have a new list of reasons that renters can be evicted, new notice periods, the evidence that landlords will have to provide if they want to evict, and then some significant changes around pets and trying to make it easier for people to have pets, and then some better clarity around ensuring that there's a fee-free way to pay rent. So I'm going to hand over to Lehana to start talking through these changes and go through some of the detail. And at the end, we'll also talk about where to go if you do need more information and more assistance to pursue these. So I'll hand over to Lehana. Thank you.
Thanks, Leo. So Leo's already mentioned this change that has already commenced. It's that rent increases have been limited to once each year. And so that means that even if you get a new agreement, in most cases, your rent can only be increased once each year. Rent can also not be increased within the first year of a new tenancy agreement. So when you move in somewhere, your rent shouldn't be increased in the first year of living there. We just wanted to note that this is not a cap on the price that rent can be increased by or to. It is a cap on the frequency. So just once each year. So before I said that this protection applies to most types of agreements, there is an exception to the once a year rent increase rule. That exception is if you signed an agreement that is for a fixed term of less than 2 years, and you signed that agreement before the 13th of December last year. So if you have one of those agreements, it may not be covered by the new rules, and we'll sort of go through an example of when that might happen. Leo, did you want to read out this example?
Yeah. So just to try and give an example of how this is working and the thinking we have to do. Alice has been in a home for the past 2 years. Last July, Alice signed a 6-month fixed term agreement, and that agreement put up the rent by $20. So that has now ended, and this month she's received a notice of a new rent increase. So it hasn't been a year since the last increase. Is that a legal increase?
Yep, so the short answer is yes, this is legal, but only because we are in a transition period here. So the reason that this rent increase is legal is that the tenancy agreement Alice signed last July falls into the exception that we just identified in the previous slide. It was less than 2 years, and the agreement was signed before the 13th of December 2024. However, since the latest rent increase occurred after December, so the one she just got now, the new laws will now apply to Alice's tenancy. So this means that moving forward, her landlord cannot increase the rent again for at least 12 months, even if she signs only a new 6-month agreement. So she's protected going forward from receiving another rent increase for 12 months. So I'm going to talk about evictions now. This is a change that, as Leo said, has not been introduced yet. The change is that no grounds evictions will soon be gone. So landlords cannot evict without grounds. They will need a legally valid reason to evict tenants. We hope that this gives tenants more security in their housing and that it reduces the likelihood of unfair evictions. These are the new reasons that a landlord will have to terminate a tenancy agreement. These reasons are that the property will be put up for sale, that the landlord or their family need to move in, that there'll be some big renovations or repairs needed, that the house will be demolished, and that the property will no longer be rented out. The big renovations reason, I think the law refers to it as significant renovations or repairs that will need to occur to the property. What hope this is the big stuff that you'd actually have to move out of the house for. So we hope that the landlord will not terminate tenancies for things like painting the walls, that it will actually be big renovations that they can use this ground for. And there are also a couple of eligibility related termination reasons that have been introduced. These are that the property is no longer part of an affordable housing program, or sorry, that you are no longer eligible for an affordable housing program, that you as a student are no longer eligible for student housing, or that you're no longer eligible for transitional housing and the property that you're in is a transitional housing property. So those are reasons that have to do with tenants' eligibility changing. Then another eligibility reason that's been introduced is that the home is part of a key worker housing program, the New South Wales government, and it's needed for a priority key worker, so that the home is needed for that program. And then there are some existing reasons for termination. So breach of the agreement still apply as a termination ground, for example, not paying rent, that the property has been sold, that the tenant passes away, hardship, that the property is uninhabitable, and that there's an employee caretaker arrangement and that arrangement has ended. So those are existing reasons that will continue when the changes are introduced. And notice periods have changed too. So if the landlord wants to terminate your tenancy, they need to give you for a fixed term agreement, and so these are when they use the new reasons to terminate a tenancy, they need to give you 60 days if the fixed term agreement is for a period of 6 months or less. And for all other agreements, they need to give 90 days. So when I say all other agreements, I mean fixed term agreements over 6 months and periodic agreements. For tenants breaching, if there's a breach alleged, the notice period that the landlord has to give is 14 days. And that's already the case currently. So that won't change. And I should say that these notice periods are a minimum. So landlords can give more than this when giving a termination notice, but they need to give at least this amount of time.
And so, one of the things that people have been worried about with these changes is, what's to stop a landlord just giving a fake reason, just making up that they're going to move in, or just making up that they're going to do some renovations. And we've been raising this as part of the development of these laws, and the government has been putting in some strategies to try and make sure that this happens. So, the main one, uh, the first one is that landlords have to provide proof of the reason for termination. Could we go on to the next slide, Lana? So landlords will need to give a termination notice that is in writing. It's got the proper days. It says why, but it also has to actually have some proof to show that they are using the correct termination with legitimate grounds. And that proof is going to be set by the government in the regulations, which are still in development, but they will be particular kinds of evidence. It's not just anything. And so that's the first strategy to try and help make sure that the reasons are valid. A second is that landlords will actually have to tell government that they've served that notice and the reason that they've served the notice. So it's not just now between the landlord and the tenant, it's now between the landlord, the tenant, and the government. And that will give government greater ability to go back and check if the reasons have been genuine. And then, so the kind of proof that they'll be required to give are still being developed, but they might look like contracts with builders if they're claiming demolition, or tradespeople if they're talking about renovations, the council approval to do this kind of work. So many of the changes, particularly demolition and significant renovations, might need consent through council, and if that's the case, that may be included. Or statutory declarations or other kinds of statement that talk to their experience, um, or talk to the reasons why they are in the situation they're in. We've been advocating that statutory declarations should usually be joined with another piece of evidence so that it's not just that by itself. But statutory declarations do come with penalties if you issue a false one. Um, there may be it may be other kinds of written statements. There are penalties for landlords who are found to have provided false reasons for termination. And so again, that's why it's important that government is receiving the reason for the termination now, because that gives them the ability to go back and check whether it's every single one or a sample. They will be able to go and check and make sure that people have a real risk that if they've lied, there is some actual consequences for that, and that goes along with tenants being able to dispute it themselves. And then the third strategy is that they are in putting in a ban on reletting for that particular property for a period, depending on the reason that they've given. Some of these are short. So the renovation reason is only 4 weeks after the termination. So after the tenancy has ended because the tenant has left, it's only a 4 week ban before they can enter into a new agreement. We thought that was too short, but that's the decision government's made. But for proposed sale, so that where they are wanting the place empty so they can prepare it for sale, demolition, or the owner moving in, all of those have a 6 month period before they can enter into a new tenancy agreement. And where they've used the ground that it's no longer going to be used as a rental, it's going to be some other purpose, then it's a 12-month ban before they can enter into another rental agreement. For some of the old existing reasons, and some of the new, the eligibility ones, there isn't a reletting period ban because the landlord isn't trying to claim that they're using it for some other purpose, like own a move in. It is more about the status of the person or the property. Um, and yeah, so Lahana, what does it look like to challenge a termination notice?
Yeah, so it's possible if tenants receive a termination notice under one of the new grounds that they can go to NCAT or attend NCAT and challenge the termination notice. They'll be able to challenge the notice either because the reason is not genuine, so the landlord isn't really moving into the property like they said they are, for example, or if the notice was not given properly. So if it doesn't contain one of the evidence requirements that it has to, or it wasn't signed. So termination notices have to be in writing and they have to follow certain rules. So if they haven't followed those rules, that might be a reason that you can challenge a termination notice.
And so, just to flesh that out, Dave was given a termination notice because the landlord's parents want to move in. He thinks the landlord's just making it up to kick him out. So, what advice would you give to Dave if that was the case?
Yeah, so I would first look at the termination notice. Like I said, it has to follow certain rules. So I look at the exact date of the termination notice and how much notice Dave was given. So we can assess if Dave received the proper written notice according to tenancy law. It also sounds like the grounds that Dave received the notice under is that the landlord or their family need to move in. So I'd check if there were any evidence documents with the notice and make sure the evidence is valid. We don't know, like Leo said, what evidence is needed exactly, but we'll know more soon. And then I just ask Dave what he wants. Does he want to stay out or does he want to move out earlier? If he wants to stay, I would tell Dave that if he overstays the notice, the landlord actually has to apply to the tribunal for eviction orders before they can evict Dave. They can't just change the locks without going to NCAT. And NCAT will then decide, like we said, if the notice is genuine and valid. They'll also be prevented, the landlord will be prevented from reletting the property for 6 months. if they use this reason to terminate a tenancy. And I'll just talk about saving a tenancy for breach or challenging a termination notice that's been given for the reason of breach by a tenant, just because it looks a bit different. So with tenancy breaches, NCAT won't just look at whether the notice is valid or genuine. They actually have discretion, meaning they can decide whether or not to let a tenant stay after a breach of the agreement. NCAT will decide if the tenant has actually breached the tenancy agreement. And if they think that the tenant has breached the agreement, NCAT will make a decision about whether the breach is actually serious enough to justify ending the agreement. So just with when it comes to breaches, it's really important for the tenant to be present at NCAT and a good idea to get some tenancy advice. But like it says on that slide, you may also be able to save a tenancy before it gets to NCAT, for example, by negotiating with the landlord, paying any overdue rent. But if it gets to NCAT, it's a good it's a good idea to get advice from your local tenancy service. And finally, we'll cover pets. Another change that has not yet been introduced. So there's a new process to apply for a pet. The process is that tenants submit a form. The form hasn't been finalised yet, but it will be a specific form they have to use to apply to keep a pet, and landlords will then have 21 days to reply. If landlords don't respond within 21 days, they are taken to have given consent. I'll also note there that assistance animals do not require consent. So if a landlord does consent, if they say yes to the tenant keeping a pet, they are allowed to impose reasonable conditions on the consent. Reasonable conditions are things like the tenant needing to clean the carpet when they move out. But there are also unreasonable conditions that landlords are not allowed to impose on the keeping of a pet. Those are things like they're not allowed to specify that the rent be increased, or that there's an additional bond for the animal, or to ask for any additional security. So those are stated as unreasonable conditions in the law. And then it's possible that a landlord says no to this application to keep a pet, but they can only say no for a specific reason, and that reason is listed in the legislation. So these reasons are that there would be too many animals in the house if the landlord says yes, that the property is unsuitable for that pet, that the animal is likely to do damage to the property that exceeds the amount of the bond, the landlord also lives at the property, or that the animal is forbidden by a law or a council order, bylaws or community rules. Or the last reason is that the tenant hasn't agreed to a condition that is reasonable. So it's really important to know that when a landlord says no, they have to specify which of these reasons they're saying no, why they're saying no, and put that in writing to the tenant within 21 days. So another example.
Yeah, so Alicia lives in an apartment with her pet Staffy Bruce, and she wants a small second dog to keep Bruce company. What would you recommend Alicia doing in this situation?
Yeah, so I'd direct Aisha to the correct form for applying to keep a pet, because that has to be used. Then if the landlord approves the pet, I would suggest checking any conditions that the landlord has set to see if they are actually reasonable conditions. I'd also remind Aisha that if she already has consent from the landlord to keep her Staffy Bruce, then that consent still stands. If the landlord says no to the pet, though, I would suggest looking at the reason for the refusal, because the landlord can only refuse a pet for those specific reasons that we stated. And I'd look at the reply to see if it all makes sense. And then I might also talk to Aisha just about the practical ways to strengthen her application. So highlighting how she will care for the pet through regular walks and training, or emphasising the pet's good temperament. So these details might help to enhance the application too.
And so, we want to make sure that people have places to get accurate and reliable information about renting in New South Wales. And we really recommend going to our website, tenants.org.au, On that site, we are updating currently the fact sheets to reflect these changes, and once we get all the specific detail, they'll be in there as well. But that site also has sample letters and tips and various blogs and other resources to help you get across the changes and understand this and every other part of renting, particularly around the law. And there's also details about the law reform activity, submissions, and campaigns that we write and are a part of to help make sure that the law is appropriate and making and provides good homes for people. But if you need advice, or if someone you know needs advice, the best people to speak to are tenant advocates at the local Tenants Advice and Advocacy Service. And the easiest way to get there is on tenants.org.au, clicking on Get Advice. You can put in your postcode, and that will give you the contact details for your local service. If for some reason you can't get through, a couple more options are the advice line that the Tenants Union runs twice a week, just to help support people who haven't been able to get through to the Tenants Advice Service, or Fair Trading New South Wales themselves. Those numbers are on the screen. The Tenants Union advice line is 1-800-251-101, and Fair Trading New South Wales 133220. And so that's our run through of the changes as we understand them now, and those aren't going to change. The regulations are still being worked out, and some parts of this will have a little bit more detail, the exact kinds of evidence around the pets. There may be sort of more restrictions or more requirements around those conditions and that kind of thing. So that is going to come out very soon. The other thing we don't know is exactly how the tribunal will interpret the new rules. So when this kind of change happens, then there's a period where people, renters, and landlords will be bringing cases to the tribunal, and the tribunal will have new rules to decide what they mean. And so we talked about an example of that earlier. What counts as a significant renovation is likely to be worked out at the tribunal and then through appeals, and then we will get to a more accurate understanding over time. We'll be in there trying to make sure that it is a good interpretation, but we don't know exactly what it'll look like. But that said, we'd really like to welcome any questions that people have. We asked for questions to be sent in ahead of time if people had them, but we're also happy to take questions now. And so we're happy to run through those. And I think we have a number of questions to answer. I'll start with Jem's there, that Jem has asked, do you know when the no grounds eviction amendments will be proclaimed and come into effect? So I'll answer that. We don't know yet. We know that government is actively working on the regulations, and that's the last bit before it becomes proclaimed. Our best guess at this stage is that it will start maybe late April, probably more likely sometime in May. But it is not yet known, and things may shift. We certainly have been saying to government it should be as soon as possible, because people need the certainty, they need the change, and there's really no reason to wait. These are sort of moment in time decisions. There doesn't need to be a lot of preparation before these changes come in. One that came in earlier was, is it legal for strata managers to ask from the renter a bond payment before the renter moves in? So this is a payment that sometimes people ask for, and it's often portrayed as not refundable even on the renter moving out. Lehana, do you have an answer for that?
Yeah, I think if you get this sort of request to pay a bond payment by the building manager or strata manager, you can assert that that is actually not legally payable for a couple of reasons. One is that under the tenancy law, you're only allowed to be charged certain amounts. That's the rent, the bond holding fee. So if you get this, you can say actually not allowed to be charged under your tenancy agreement. Also, there's other sections of the Residential Tenancies Act that says you can only be charged one rental bond for each tenancy, for each agreement. And it doesn't just say that the landlord or landlord's agent must not require more than one bond. It actually says or any other person. So that I think you can definitely assert that this is not legal if this comes up.
Mm. And so another question that had come in ahead of time was, is there a law already or a plan to introduce a maximum increase to weekly rent? So, for example, that weekly rent can't be increased by more than a certain amount or only a certain number of times per year. And so we talked about that they have now changed the rule so that it is only one time per year. That had been in place for periodic agreements, which was sort of nearly half of tenancies in New South Wales, but now it's extended to everybody. Um, there isn't currently a plan from government to introduce a maximum increase to weekly rent. The rule in New South Wales is that it has to be a not excessive increase. And if someone receives a rent increase, you can contest that rent increase and take it to the tribunal, and they will work out whether or not the particular increase is excessive. And that's been really difficult for a long time because you could be evicted, and we had cases where people did apply to the tribunal to challenge a rent increase and found themselves evicted shortly afterwards. And so that, put a real chilling effect on people's willingness to contest things like rent increases. With the eviction reform, it may become easier to challenge rent increases and to look at the number of reasons that the tribunal has to consider whether or not the rent increase is excessive or not. So it is mostly about what other rents in the area are doing for similar properties, but it also takes into account, the quality of the property, the age of the property, and so you can make arguments around that. But it is a bit tough still when the market for rents is increasing really rapidly. It may be that even if you do go to the tribunal, it still seems like an unfair and excessive increase because the market has gone so wrong. So we will continue to advocate for a better rent pricing system to make sure that we do have protection against really rapid rent increases that really race ahead of people's ability to pay and displace people from their communities, from the areas that they need to stay in. So that will be ongoing work to undertake. We also had a question about a campaign for long-term rentals, whether one was going to be initiated. And I think that the question is probably about long fixed terms. So, moving in, and quite a lot of people know that, say, in Germany, it is really ordinary for you to move in and be given a 10-year fixed contract. And so you have that security for a much longer period. In New South Wales, there's no restriction on how long a tenancy can be, up to 98 years. So you can be given a 98-year agreement. And the reason that it doesn't happen is that landlords don't want to. So the there is some interest within government, and people often raise the prospect of longer term fixed terms, and that can be a good solution, but it can come with some traps as well. What you don't want to do is put in place a long fixed term, say 10 years, and then 3 years in, 4 years in, you realize that you need to move, whether it's for work or for family, and then you're hit with really heavy fees. Um, and for tenancy agreements in New South Wales at the moment, if you're in an agreement longer than 3 years, then there's no then the break fee system that's in place that limits the costs of breaking a lease for under 3-year agreements doesn't apply. And so you might find yourself with really quite hefty penalties for leaving. Um, Whether that's, the rent until a new tenant moves in, or so on. So it'll be important to make sure that people still have the flexibility to move when they need to, but have the security. I think that the no grounds eviction reform is going to slowly change the way that people, both agents and tenants, think of tenancy agreements, because there isn't as much of a benefit to being on a fixed term now for tenants, because you will have a longer period and a more limited number of reasons that the tenancy can come to an end. But we'll see what happens over time. And then the last question that we have in at the moment is, when will the Act be changed so that inspections aren't happening currently 4 times a year, and make that longer. So maybe only twice a year, 6 months, once every 6 months, or even once a year. And it's a good question. We know that inspections are something that people find really invasive in their experience. They, feel like they're taking care of the place, they're living their life, and the inspection comes in, and it makes people feel, really scrutinized. It feels like an invasion of privacy, and it feels like you're being judged often for things that aren't actually really part of the tenancy agreement. So, whether you've folded your clothes neatly and so on, which has nothing to do with whether you've complied with the tenancy agreement. So we certainly think that the inspection process should be fixed and made to better respect tenants' privacy. The purpose of inspections should be about checking on the maintenance needs of the property. Are there repairs that need to be done? Is there mold that needs to be taken care of? And it is good for a agent or landlord to be aware of these issues and to make sure that they're responding. And so the trick is finding the balance between having uh, good, maintenance schedules and good maintenance programs with the privacy. And so probably 4 times a year isn't necessary, and and maybe longer would be better. So uh, we'll see what happens once these reforms are in place, and once we've been able to look at what should come next. It may be that that kind of inspection, the regime, is something that starts to be examined more closely. So, if there are any other questions, please put them in the chat if you'd like. Otherwise, we'll start to wrap up. And thank you for coming, for the people who are here online. And if you're watching this later in the recording, thank you. We hope that this is really useful, both for yourself to understand the new rules, but also for people to be able to share with their friends, with their family, that these changes are coming. They are going to be positive, but you do need to know what they are in order to get the benefit. So thank you all again for coming. Thank you, Lehana, for your expertise and explanation of these rules. And have a great night, everybody.
Thanks, everyone.